Hi, welcome to the fifth seminar of Schwegman, Lundberg, and Woosner's Life Sciences Seminar Series. I am Nicholas Lanzatella, your moderator for the series. During this series, attorneys from the SLW law firm having a background in chemistry or biology will present on various topics in the life sciences and patent law. If you attend 3 or more of these presentations live and you have a U.S. mailing address, we will send you a free gift. Slides for today's presentation will be available in the chat, and a link will be emailed to you. As a quick reminder, nothing in today's presentation should be regarded as legal advice. If you are seeking legal advice, please consult your legal counsel. I am very pleased to introduce our speaker for today, my colleague, Ryan Connell. Ryan is a principal at the firm and is a patent attorney with experience in chemical engineering, materials science, biotechnology, and organic chemistry. Ryan also has experience in a variety of mechanical and electromechanical related arts. Ryan received his bachelor's in biochemistry and molecular biology and his bachelor's in chemistry from the University of Minnesota Duluth and his master's in organic chemistry from the University of Minnesota Duluth. Ryan received his law degree from the University of Minnesota. The title of today's presentation is Inventorship and Assignment, Practical Considerations for Your Patents. If you have any questions, please put these in the Q&A. That's the little Q&A button at the bottom of your Zoom screen. Click into that and type in your question, and Ryan will answer these live during the presentation. Feel free to ask during the presentation or at the end. Anytime works. All right, take it away, Ryan.
Thank you, Nicholas, and thank you to all those who are attending live or to anyone who's accessing this presentation via our link and watching it afterward. Really appreciate your time, and I look forward to getting into this presentation. So today's presentation is a little generic in that it discusses inventorship and assignment of patents. Obviously, this issue is not exclusive to chemical and biochemical. However, one thing I've noticed in my practice, going across different technologies, be as with biochem and chemistry, is like compared to some others, like mechanical, electrical, mechanical. Oftentimes in the chemical biochem realm, as you may be aware, there's oftentimes quite an interesting relationship in parties that come together to make a patent. There's quite a bit of joint development agreements, cross-institutional, or in a university, you might have, professor, graduate student, undergrad, postdoc, all sorts of different relationships. And sometimes inventorship, assignment, who actually owns the patent, tends to get a little sticky, if you will. I often joke about patent law that there's a reason why your legal dramas typically aren't focused on patent law. I mean, so there's that windshield wiper Ford movie, I think. But other than that, it's a pretty, uneventful area of law compared to your criminal and all that stuff. However, if there was going to be a legal drama based on patent law, inventorship and assignment is where it can get a little intense and would be a good fodder for it. So let's just kind of get into this and talk about the relationship of inventorship and assignment. So why is inventorship relevant? Well, I mean, patents is all about inventors, but when you look at our Constitution, inventors are explicitly called out in Article 1, Section 8, saying that inventors have exclusive right to their writings and discoveries. So the rights of an inventor to a patent is explicitly spelled out in the Constitution. Assignment, of course, is relevant because it's something that once you have a patent in hand or you have some patent rights as an inventor, you can do with them what you want, either keep them or sell them or give them to somebody by way of assignment. And as I'm sure most of you are aware who have been in the patent space, the vast majority of patents that you come across are actually assigned from an inventor, likely to their employer. This is because patents are property and can be done with what an inventor wants to do or what is obligated by way of contract to do. So inventorship versus assignment. Again, inventorship and ownership are completely different concepts. The owner enjoys all rights given provided by the patent and are by operation of law vested with ownership of the patent outright. So absent any agreement to the contrary, whoever is classified legally as an inventor owns all rights to the patent. However, as I said before, they're often obligated to give those rights to another party, typically your employer, the inventor's employer. And what's so powerful about assignment is once the inventor actually assigns the rights to the patent, the inventor who assigned has no rights to the patent anymore. It's all transferred by way of assignment. So let's dig into each of these concepts individually here and talk about some tie-ins to the chem bio space. Okay, so inventorship. Whoever's listed as an inventor has to meet a legal standard for inventorship. It's actually, if you're not aware of this before, who qualifies an inventor is actually, it's actually a legal term of art. It's not just somebody worked on something so they get to be classified as an inventor. We'll get into that in a little bit. According to the in patent law, in the United States, an inventor is somebody who contributed to the conception of a claimed invention. So conception is a pretty important key word in this and merits some discussion. Conception is defined as the formation in the mind of the inventor of a definite and permanent idea of the complete and operative invention as it is thereafter applied in practice. Okay, that one's a little cumbersome, but let's get into that a little bit more. To put that into plain English, a person who has conceived of an invention when their idea is clear enough to enable one of skilled art to implement the invention in practical form. Essentially, it means the way I think about it is you're an inventor if you have conceived of something clear enough that you can describe it in so much detail that somebody who's also in that technical space can actually understand what the heck you did. The reduction to practice is interesting. Something that trips some people up is that you don't actually have to have made your invention. So, just to use a chemical example, if you have a molecule in mind that you think might have some effect, you don't have to actually synthesize the thing. It's enough that you can, conceive of the structure, how it can function, and how you can make it. That's called a constructive reduction to practice, as opposed to an actual reduction to practice. Inventorship, something that can kind of trip people up, especially if they're newer to this, is that inventorship is, in the United States, is based only on the claims, the actual claims that are filed. If somebody was part of a project and their contribution made it, say, into the detailed description or the example, or in an example in the application, but not in the claim, they're not an inventor because it's not in the claims. Some countries will allow inventorship based on what's in the body or the disclosure of the patent application, but not the US. So what actually ends up in the claim is what determines inventorship. So this is where it can get kind of sticky, though, is I'm going to use a university as an example. So say that you are in a university and you have your professor, PI, postdoc, and maybe a graduate student. Okay, so it can happen sometimes that in grad school, right? Say you're a graduate student working on the bench, and your PI or postdoc comes to you with a synthetic scheme to create a molecule that they are targeting. And you follow the synthetic scheme step by step, make the molecule, and that molecule is what is actually the subject of the patent. So, and then the university files patent application and you're not named as an inventor. You might feel a little left out. You might feel that, hey, I made the darn thing. But the truth is that in most cases, something like this, you've been given the instructions to follow, you haven't actually done the conception or conceived of the invention. You're just kind of following steps. This is where you are not eligible to be listed as an inventor because you just followed steps that were presented to you. The professor or postdoc, whoever conceived of the molecule in the synthetic scheme, in that case would be listed as the inventor if you're just following step by step. Open question, if you were the graduate student and you thought of putting a different functional group or modifying the molecules somewhat, and that makes it into the application, well, then maybe. But this is where, again, things can get kind of sticky as you're going through the reduction to practice, be conceptual or actual. Inventorship isn't limited to just one inventor. This is kind of obvious. It can have multiple inventors. And you don't have to have equal contributions. So say you have one claim and it was a team effort to come up with that claim, and maybe just to make it easy, say there were two people, person one contributed, like, I know this is kind of arbitrary, but 70% or so of the conception, inventor two, 30%. Each inventor has the same claim of inventorship. You don't, in the United States, you don't allocate proportions. And to be an inventor on a patent, you only have to have contributed to the conception of one claim. So say there are 20 claims, and inventor one conceived of the subject matter of 19 of them, inventor two conceived of only one claim, both equal inventors. This is a big one in the chem biospace too, because so much of chemistry and biochem technology is driven by academic publication in conjunction with patents. The standards for authorship in a scientific article versus inventorship are not the same, right? And a journal article is much more inclusive, right? It doesn't matter if it was your, if the idea originated with you or not. It's just as long as you helped, generally, you're eligible to be listed as an author. Not the same in patents, right? Because inventorship is a very defined legal concept. So this is where, in the chem bio space, where I've had to advise clients very carefully about making sure that you're listing the appropriate inventors and not defaulting to the article standards just because there are legal significance to being listed as an inventor, namely the ownership rights. Some companies I've worked with understand that people who helped to contribute to the reduction to practice of an invention, but don't meet the inventorship standards, rightly feel a little miffed or left out. Some companies have softened this by having like a acknowledgement structure within the company, so that even if you don't get listed as an inventor, you get some recognition or something to put on your resume to show your supervisors, just to kind of soften that landing so they don't feel so left out if they can't meet the basis of being an inventor. As far as who can be an inventor, it has to be a person. It can't be a company. So you can't list in the US, you can't list the company as the inventor. Companies get listed by way of assignment if the inventor's assigned. Inventorship is a federal law issue, not state. So you have to resolve that there. AI and inventorship, AI is really, taking off in the recent years. Some mixed bag on if inventorship, if AI can be an inventor. South Africa allowed one in 2021. Of course, in South Africa, it's kind of a quirk in that patents aren't examined. There's kind of granted, and then it's up to a third party to challenge it. The Australian federal court allowed one, but it's just kind of, to be determined to see how it goes. At least in the EP, European Patent Office, it's not allowed. US has made clear that's got to be human. with this mixed bag, you just got to be careful out there because you can imagine a situation where some countries might have an AI inventor, some not. What does that mean? Can you challenge across the globe for different inventors? How can there be different? It's all very tricky out there. We'll see how this shakes out over the next couple of years. So sometimes as a patent attorney, you find yourself, inspired by your clients and getting a little bit creative. This is a way as a patent attorney, if you're a patent attorney out there, or if you're a client and you've got a patent attorney working on this, just be careful about having your patent attorney listed as an inventor. I try to avoid it myself. It just doesn't seem right to insert yourself in your client's stuff. And also, I feel like as a patent attorney, you're more drawing out the invention and embodiments where appropriate with your client and trying to add to it, get them to kind of help them to think of variations and whatnot. They're all within the original scope of their application. And in some cases, like the one I've listed below here, Solomon versus Kimberly Clark, a patent attorney was trying to assert themselves as an inventor because of some stuff that they drew out during the course of prosecution, but the court struck that down pretty handily. One thing about inventorship is that it is not static. Again, going back to one of my earlier slides, inventorship is determined based on the subject matter of the claims. For those of you who have been through the patent process, you know that the claims can and often do change, right? During the course of prosecution, you might narrow or even broaden the claims. You might bring in subject matter that wasn't in the claim originally, but was maybe in an example or an alternative embodiment. And maybe that additional subject matter that you put in was conceived of by somebody else. In that case, you might have different inventorship. And this is something that you will have to update for sure, because you need to have your inventorship accurate. One thing that can help, and I've done this with clients where there's a huge pool of possible inventors. When you get a disclosure, typically you get a few people listed who worked on the project. If there's only like 3 or 4 or so, it's easy to keep track of who may be inventor, who might not be. But when you're starting to get into cross-institutional joint development or even some university settings, it's not terribly uncommon that the pool of possible inventors can start to expand, like 8, 10 or so. Sometimes it's helpful. I've done this where you kind of create a chart of kind of concepts and start to try to assign people to their concepts, just so that you can keep an eye on during prosecution what concepts might find their way into the claims, and then see if you need to reassess inventorship. That's especially helpful after you file the application and you're looking at 3 years down the line until it actually gets picked up for examination. My memory's not that awesome, so going back 3 years to remember who might be an inventor is a little challenging. That's kind of one way that you can keep track of your prosecution, to see if inventorship needs to be revisited, because you will have to update that. Also, when you're listing out the inventors, whoever you list first is who is listed as the inventor on the cover sheet of the application, as when it's abbreviated. So this is where high drama in patent law can come up. If there's ever to be like a Jerry Springer on patent law, this typically is where it can get heated. As far as legal significance goes, there's no priority rights or any benefit of anyone being listed first, other than their name gets listed when the patent is abbreviated. I know that this is different in academic articles, right? Because typically the first listed is the most significant, did the most work. whatnot. So, but not so in patents. But that doesn't mean that in reality that personal egos, corporate politics, all that stuff doesn't get involved. If you do find yourself managing a case with a bunch of inventors, you'll make your life easier if you just ask early on who wants to be the first listed inventor. Some clients I've worked with actually have a embedded corporate policy that inventors, unless otherwise agreed, are just listed in alphabetical order of their last name. That seems to calm things down. I strongly suggest, though, getting inventorship, the order, sorted out as soon as possible, just because once your application is filed, you have to actually, if you want to change it around, you have to file some stuff with the PTO, and it's just an unnecessary expenditure of money and kind of a pain. And also, once the application is published, the order on the published application isn't changing anymore. Good news about inventorship, even though it is static, it is correctable. Things change, and you can change inventorship, through a couple of means. Just so long. The main thing is that there can't be deceptive intent. So it just has to be, honest mistake that inventor was overlooked, or that you added some subject matter claims that changed things. So by and large, it can be changed. This is just an example here of one that of what an order changing inventorship looks like. Pretty basic after you file, and you can even do it after it's issued. So you can change inventorship during prosecution or following issuance, whatever circumstances dictate. So moving on to the other hand, assignment. As I said earlier, if you're the inventor, you are the initial owner of the patent application. However, of course, most inventors are employed by a company, or they might be, founders of a small company, but they are typically obligated to assign those rights to the company, so the company becomes the owner. Those obligations can arise from a hiring agreement, where as part of your employment, you're obligated to assign all rights to the company. It can be done later. This happens sometimes in startup companies that they're just getting their feet on the ground. They've got an idea, they want to get it patented as soon as possible, just to get some tangible asset. And then they kind of, once the dust is settled, they typically try to get it assigned to whatever entity they're forming or are planning to form. There's some other ways that assignment can arise even absent an agreement. If you're hired as a technical person, or hired to make inventions by a company, and you use company resources, there can be, that's referred to as shop rights, if you will. So you can kind of be kind of implicitly obligated to assign your patent, or the company that hired you to invent. And if you did an invention within the scope of your employment, they can have an implied license to practice it. If you're a corporate officer and you, this one's a little wonky, but if you're a corporate officer and you do some inventions and they're kind of tangentially at least related to your company, you might have a fiduciary duty to sign. That one's a little bit a little rare, but can come up. So yeah, if you're going through, if you are an employee and you're doing some inventive work, or you're managing employees, be sure to check consulting agreements, or your employment agreement, to see what the rights are in assigning a patent or not. And this is the assignment's important. Yes.
Ryan, quick question. This goes back to some of your inventorship examples. The question is, after issuance, does change of inventorship have to be affected through court, I think the example you showed on that slide was a court judgment, and the questioner is wondering if it has to be done through court or if there's another way to do it.
Yeah, I think there's a regulatory way to do it as well.
Okay.
Good question. Yeah. Okay, so assignment. So assignment's important, and this is where if you're looking to spin off a product, or if you're looking to acquire a company that has an IP asset, this is where in a due diligence exercise, this is where a deal can really get sticky. Um, Joint owners of a patent have an equal, undivided right to make, use, offer to sell, or sell the invention without the consent of joint owners. So what does that mean? That means, as an example, let's make it easy. Say you have two inventors on a patent. If they each inventor who hasn't assigned any right in that patent can do whatever the heck they want with their rights in the patent. So you could, person A could hold on to their rights, and then person B maybe sells or assigns their rights to some different companies. So then you could have a situation where you've got an individual inventor and a company owning the invention, and they can sell it, license it, practice it, do whatever they want independent of each other, just ships passing in the night. Whereas if each inventor were to assign it to a common entity, then you just have one entity controlling what's done with that invention. So you can kind of imagine the potential mess here if there's joint ownership and as opposed to it being assigned. And as an example of how messy this can get, if you have rogue inventors, consider Ethicon versus U.S. Surgical Corp. So in this case, company Ethicon sued U.S. Surgical for patent infringement, and lo and behold, there was an omitted inventor, and that omitted inventor got a hold of U.S. Surgical and decided to go ahead and license their rights to the patent to U.S. Surgical. So guess what? Now you have Ethicon owning undivided interest in the patent, and you have U.S. Surgical owning an undivided interest in the patent. In the court, obviously Ethicon fought this and said this new inventor isn't an inventor, but the court found that the omitted inventor was. So as a result, U.S. Surgical wasn't infringing the patent because they had a license that was just given to them. So the case was dismissed. This here is an example of what can happen if you don't have your inventorship buttoned up before you release your patent out into the wild. Because as some of you maybe have been through litigation, as you know, when it comes to high stakes litigation, litigators leave no stone unturned, and in this case, an inventor was discovered. So this is why you want to really keep track of that application. I don't know how this inventor, or forget how this inventor came to be. I don't know if something was amended into a claim during prosecution and they just forgot to update him or something. I'm not sure. But the point is, make sure inventorship is buttoned up, and hopefully well ahead of a litigation, just to make sure that you don't find yourself in this situation.
Ryan, a couple questions about the situation here in Ethicon. Was I'm not sure how recently you read the case in detail, but one question is, what wasn't the omitted inventor obligated to assign to the company?
I'm not sure. Yeah, I'm sorry, I don't remember that
I mean,
detail. They
since it was dismissed, apparently not.
That would
Apparently
be my
somehow
guess. Yeah,
they slipped through that. And
yeah.
another question here is, how can an omitted inventor be considered by U.S. Surgical as a patent owner? And I think this goes back to some of the earlier things you were talking about.
Yeah, I'm
Uh,
not. Again, I don't remember what circumstances led to them being an omitted inventor. It could have been that they, contributed. I mean, obviously they contributed to the conception of at least one claim and went through, the detailed analysis in the court. I just can't remember if it was that they were just omitted from the beginning on the original claims, or if they were found, or if an amendment came in with some subject matter that they were listed as an inventor on. Sorry, it's been a little bit since I read it and put these together, so sorry, but yeah.
Sure. Well, I mean, I think one important point here is that, the inventors are the original owners. So
Yes.
if you omit an inventor and it's later determined that person is an inventor, that person becomes an owner
Yep.
who never assigned their rights. So this really can happen if you accidentally omit someone who is a proper inventor. There can be another owner that appears. And like you said, that owner is going to have undivided rights to do what they want with the technology.
Indeed. And this is also now this I'm just using this as a hypothetical here, but this is where, if you have a situation where you have a joint development agreement, so say university plus a company, company A plus company B, university A versus university B, if, just one of those two entities might, so say you have company A and company B, and company A decides that only their people were inventors and they file and they have it buttoned up so that all their inventors assigned to company A, and then say company B decides that they had a person who was an inventor. You might have company A with everyone assigned properly, but then, company B has their people and they come up and prove inventorship. So this is where if you start to do these cross developments, you have to really be careful. Sometimes it's contracted even in the joint development agreement that, everyone assigns to one company or assignment is to both. These are all things that can be contracted for in advance. But I think, the takeaway of this Ethicon case, right, is just whatever you do, make sure it's buttoned up. And especially, when you have cases where you might have quite a few inventors, like I was saying earlier, a little bit of a chart can be helpful as circumstances change. Kind of an interesting thing to think about here too is community property and IP ownership. So, if you're in some community property states like California or up here in Washington, where I'm located, those are community property states. And so an inventor who has an invention and not assigned, is that asset something that is community property during a marriage, for instance? Can that apply to patents? Well, a little bit unresolved. There was one case that I found here where a person was sued and it was, I believe, not assigned, and and it was argued that an inventor's ex-wife was a co-owner of the asset based on community property laws. However, this case had a divorce. The divorce happened before the case, and there was a decree resolving ownership, so it was excluded from community property. But one wonders, what if there was no divorce, no state court judgment? How's ownership divided? And an unassigned patent that's in a marriage. Kind of interesting. I wrote, oh gosh, back in 2015 or 2016, I wrote an article. I think it's in Trust and Estates magazine about IP in your estate plan. Yeah, it's probably somewhere on Google. Probably can help with insomnia if you want to take a read, but kind of an interesting thing to think about. An assignment just at its core is really just contract law. To make an assignment, pretty easy. You just need to meet the big three: offer, acceptance, consideration. Again, typically these are part of an employment offer. However, and just for consideration, so consideration is just something given back to somebody for signing the contract. It can be pretty nominal. I've seen assignments for $1. as low as, but it can really be anything. Um, even though, these assignments in contract law, even if somebody has an obligation to assign present in their employment agreement, it is overwhelmingly typical and, in fact, advisable to execute a separate assignment per patent, just so that it's buttoned up. You don't want to be in a situation where, say, you're about to sell your IP, spin it out, do something with it, and then when you're the acquiring party does a diligence or something, and they're looking through and trying to find the assignment, and you just say, "Oh, it was in the employment agreement." Do you really want to be digging through and finding an employment agreement that's, might not be readily apparent, or there might be some stuff in there that you don't just want released out there and have to go through action and all that stuff. Far better just to execute an individual assignment per patent. And the assignment form, these are just an example here. These can be ginned up by an attorney pretty simply, just to have a basic contract with, kind of these, calls out the name of the assignees, the number of the patent if possible, title, and then, just kind of some boilerplate-ish language, if you will, that, meets the offer acceptance consideration standards. And again, if attorneys can whip this up pretty quick, you do need to notarize it and have it witnessed, but that's typically not the most cumbersome thing in the world to do. Once you do assign, though, and this is important, you're going to want to perfect the assignment, simply meaning that you want to record evidence of that assignment with the United States Patent Office. That's what allows it to be looked up. There's a whole database you can search for these things. And again, this is if you're in a position that you're trying to sell your IP or something like that, this is one of the first things that will be examined during a diligence operation to make sure that it is in fact assigned, and that there's a clean chain of title going from inventor to whatever company is trying to sell this, just to make sure that's all tied up and nice and tidy, because you just don't want gaps in ownership, so that something bad like Ethicon can come up. Once you do get it filed, this is, if you haven't seen it before, this is what you'll pull from the patent office. It gives a chain of title, and just kind of shows how the ownership has evolved by the assignment over the years. And timeliness of recording assignments is important. You're going to want to do this just as soon as you can, because there's this thing that if you don't assign it timely, or excuse me, if you do not record the assignment within 3 months of the date the assignment is executed, it's awfully hard to use that to skip ahead of people who might have some sort of interest in that IP asset, just because they haven't had proper notice. So you gotta, there's really no reason why you don't want to assign or record your assignment with the patent office the same day that you get them all executed. This is an analogous concept to for those of you who've been unfortunate enough to have to take securities and exchanges law, like I did in law school. Yes, just like recording a security interest in any other asset, you want to do this as soon as possible. Another reason to get this stuff buttoned up quick, you'll often find, sometimes inventors are mobile, right? They might go to different companies. They might, if they're at a university, they might graduate or go to a different institution. Sometimes when inventors change jobs, even if they're obligated to assign, it can be tricky to track them down. So it's in your best interest, just, assign as soon as possible. It's not uncommon that when you have your final draft and have it reviewed, and when you file the patent application, that you send out assignments same day. It's in your interest to do that as soon as you can. And even at an early stage of filing a provisional patent application, before you file any PCT, US non-provisionals, any of that stuff. I would just urge you to consider doing an assignment as soon as possible, because as people move on, or if they leave a company under bitter circumstances, it'll just make your life easier to get it signed as soon as possible. The good news about assignments too, it comes up that there are errors in it. Names might be misspelled. Wrong company names are quite common. There's the hits of the company name, comma, Inc. versus the company name without a comma in Inc. Sometimes Inc. is all caps. Sometimes Inc. is a mix. Sometimes there's LLC. These are just kind of the greatest hits of assignment errors. Wrong patent number can be listed. Good news is super easy to fix. This is an example of how it's fixed. As you can see, it's not the most labor-intensive thing to do, but it is good to make sure that they get it all buttoned up, because again, you don't want some litigator or diligence attorney. You don't want to give them an avenue to make a mountain out of a mound. So better to just get it buttoned up and fixed as soon as you see it. So, I mentioned that you don't want to rely necessarily on the employment or consulting agreement in the absence of a assignment, but it's just good to have both. I mean, this is kind of a captain obvious statement, but good if you have an employment agreement that obligates assignments, or if you have any employment agreement in general, make sure you have an invention assignment clause just as a stopgap in the event that you don't have an executed assignment. It's handy. It's come in handy in my practice a bunch of times too, where an inventor's left a company before signing an assignment and doesn't feel particularly warm to the ex company. We have relied on an employment agreement that has an obligation to assign to tidy up the chain of title. And in the absence of an executed assignment, you can use that. You can record that employment agreement as a proof of assignment, but again, not the first arrow in the quiver you want to use, just in case there's some stuff you don't want public, or be forced to go through redaction, which is not the most fun to do. So assignment versus licensing, just because some people might get it a little confused. So assignment means that you own it. Licensing just means that you're giving the rights to use an invention. It's like renting versus leasing a car, or buying a house versus renting an apartment. If you have assigned something, someone else owns it. If you're licensing, you're just giving rights to use, make, use, or sell the subject matter of a patent application. Licensing can come in all sorts of different forms. In a license, you can limit it to a field of use. You can limit it to a geographical territory. You can set the term of license for a specific amount of time. You can make the license exclusive to one entity or a group of entities, or you can make it non-exclusive, meaning that you reserve the right to license it to as many people as you please. What's interesting in an assignment too is, I mentioned earlier, right, that if you're co-inventors, no matter if you contributed to 70% of the subject matter versus 30, you have an equal and undivided right to make, use, or sell. In an assignment, you can actually slice up the ownership in different ways. Not common that I've seen, but that's just contract law. So you can really kind of do whatever your creativeness in drafting up the assignment lets you do. But yeah, it's just kind of assignment and licensing is where you can kind of escape to some degree the rather prescriptive ownership rights assigned to inventorship. Just a few kind of ancillary concepts here before we close out. assigner estoppel is kind of interesting. Um, in general here, that this can get a little sticky, but um, in general, an assigner is not able to challenge a patent for invalidity in litigation. This is kind of an interesting little side topic. Licensee estoppel, and I'm sorry, I'm kind of whipping through these a little bit faster because we're running up close to time. Um, Licensee estoppel. So this is a situation where somebody holds a license to a patent and maybe is getting a little tired of paying their licensing fees and decides maybe it'd be more cost effective. This one example decides to get out from under it by saying, this patent I've been licensing, I don't think it's valid. There was some stuff, previous cases that said, well, that's not equitable if you're paying for the license and you want to get out of it by challenging the validity. That doctrine got overturned eventually, way back when, in 1969. So generally, a licensee is stopped from challenging the validity of a patent. Just, again, the stuff, it's very, there's just a lot to keep track of with inventorship and assignment. If you have, if you're on the legal side, if you're at a law firm, for instance, you might have an internal docket system that you manage all these, or, client side, you may have it as well. Or if you're, a client and you don't have an internal docketing system yet, you can, have your law firm manage that and keep track of these things. I have FIP listed, Foundation IP as a example system. Also, the nice thing is a lot of this is public record. So you can, track the patent office to check inventorship, assignments, and just see who actually owns something. And conversely, for your own IP portfolio, you can easily access the PTO to see kind of what the official posture is of ownership of your IP. So again, all this wasn't too terribly specific to chem biotech practice, except that just with the nature of development in this field, it really does come up a lot, more so even, than compared to when I, my practice in other areas outside chem bio. It's just is a common occurrence thing here. So I think that the take home is just keep track of these things. You just want to really make sure these problems or potential problems are nipped early in the process before they become something that is really just too much to handle. Hope you enjoyed the talk. Feel free to email me with any questions you might have, or if you have any now. Happy to discuss this, and thank you all so much for your attendance.
Ryan, thank you very much for that excellent overview. We do have a few questions queued up here. Would you please skip up to the slide on how do you perfect assignment continued, where you quote 35 USC section 261? You've got some red text on that. That's the one. So the question here is, let's see here. Regarding 3 months, there's this void after 3 months if not recorded. Is that only if it's purchased later that assignment is void, or is that in all cases? Is there a blanket rule that assignments are void unless they're recorded within 3 months?
Sorry, say that again. It's not. Sorry, what was the condition on that again? Sorry.
Well, it seems like this text here that you've quoted says an assignment is void unless it is recorded within 3 months. Is that only the case if it's sold? Is only if it's purchased later, or in all cases? What do you think?
Well, yeah, it would have to be against a later purchase, right? Because that's how it would arise. So yeah, it'd be so if you um, grant or convey it, don't record it, and then 3 months later, um, it's assigned again or sold, and then then the first person who didn't record it comes up and says, no, 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 I own this. I have had it assigned before. They're kind of out of luck at that point because they didn't record it, so there wasn't that public notice that it was already spoken for.
Yeah, that makes sense. Another
Yeah.
another question is, um, this regards correction of assignment. So if an inventor only conceived one of the claims, and during prosecution that claim is canceled or withdrawn and doesn't end up in the issued claims,
Mhm.
do you need a new assignment since they are no longer an inventor?
Hmm. That's a good question. That one hasn't come across me, so don't hold me to this, but you're going to want to, at a minimum, correct inventorship. The assignment, I don't, my instinct is I don't think you really need to because the assignment just says I assign my rights in the patent blah, blah, to and those rights can be actual or, nothing. So I
Yeah,
don't,
I
I
agree.
don't
It
think, yeah,
it seems like the assignment just sits there and does nothing. It doesn't
yeah,
need to be corrected because it's not doing anything. So I think
yeah,
the answer is a new assignment is not needed, but the inventorship should be corrected.
yeah,
Let's see here. Another question is how widely accepted are e-signatures on patent assignments? And we have another questioner who commented, um, DocuSign may be okay on U.S. declarations too, but many foreign jurisdictions will not accept electronic signatures on assignments. So,
yeah.
wondering if you could just talk a little bit about e-signatures.
Yeah, I don't know about you, Nicholas, but I've really not done e-sigs for the assignments. I've just relied on, oftentimes it's just a real signature and the documents are scanned and sent back. I haven't, yeah, that's been my practice just for, belts and suspenders approach.
That's what I usually do too. What about notarizations? Are those required on assignment documents? The answer is probably that it varies by jurisdiction, but what's been your experience?
Yeah, in the US, yeah, notarized.
Another question is, can you provide any comments about drafting and recording a memorandum of assignment um, instead of recording that instead of a large acquisition agreement? This is the question. I'm not sure if I totally understand the question,
Or
honestly.
maybe that means instead of a acquisition agreement. Um, So I guess there's two two interpretations I have of that. Maybe hopefully one of them is correct. So maybe that means instead of an employment agreement, or if the acquisition acquired, because sometimes when you acquire, right, there's a kind of a blanket assignment of patents, one through whatever that are being acquired, and then you do a large assignment of all those to the new company. Um, I guess I haven't done though like a memorandum summarizing all that. If that's the question, it's pretty the assignment. It's the consequences are so great. I would kind of stick to the book. Sorry to be boring about it, but I would either button if you acquire them, either button up individually assigning, having the acquired company execute an assignment of each patent or group of patents to the new company or whatnot. I wouldn't try to do anything other than that, just again because the stakes are just can be too high.
Here's another question. What are your recommendations for best practices for recording assignments in continuations or divisionals?
Yeah, good question. Um, you know, I would do it. Oftentimes, the assignment document would have language saying, that they assign all continuations, divisionals, and whatnot. But I don't know about maybe you differ, Nicholas, but I view those clauses as something you want to use for defense, not for offense. I would
Sure.
rather. I feel better about just the assignment's not hard. Just I feel like just do it again, so that only rely on those clauses if needed in a pinch.
So what happens if a company can't get a signature from a former employee for a patent assignment? I think you
Yeah.
talked about this briefly about some of the things that can be done, but maybe you could just
Yeah.
talk about that for a minute. What does a company do in that situation?
Yeah, try to get a substitute, prove up an obligate. You have to prove up an obligation to assign that they were under an obligation to assign rights in that patent, and you can file that if needed. That's really the most effective backup. But ideally, you have that in an employment agreement or some communication. But yeah, that's your best path.
So this is a situation I've run into a number of times in my practice, and certainly the easiest solution, I agree, is if there is a already signed employment agreement that uses the language, that the employee hereby does assign all inventions made during the employ with the company. That's definitely the easiest way forward to overcome that situation. Another question here is, and I'm not sure if you have this ready, but the question is, when is a 3.73C statement used? I'm not sure if you talked about those in this presentation.
No, I
If it
didn't.
doesn't ring a bell, if it doesn't ring a bell, we'll just
Yeah.
whoever asked that question, please email Ryan and he'll do a little research on that and he can get you an answer on that. Um, And here's one more question, a little longer question. Suppose the company has a quote unquote present assignment of future inventions
Mhm,
clause in the employment agreement, but you want to record a confirmatory assignment.
mhm.
Do you treat it as a regular assignment where the PTO only asked for a date of signature, or do you treat it as a nunc-pro-tunc assignment for recordation and put an effective date of the filing date in the confirmatory assignment?
Good question. I think I would just put in my instinct is yeah, just the date of recording the confirmatory assignment. I don't think that would have any adverse effects, and it's the date that you're assigning the patent. Yeah, I would just put in the date that you're following up with the assignment is my instinct.
Okay. Well, thank you so much, Ryan. That was a very useful overview, and I appreciate you answering all those questions. If you do have any additional questions, all those who are attending, please feel free to email the presenter. Slides for today's presentation are available in the chat, and a link will also be emailed to you. The next SLW Life Sciences Series seminar is currently planned for Tuesday, April 8th. I hope you will attend the next seminar. Thank you so much for your attention today. Have a great day.